I try to share my slides. Right? Is this correct? Oh. Okay. Voila. Thank you very much, Dorothy. Thank you, everyone. I have already provided my welcome today. My topic is the right of whistleblowers not to be punished and state corporate failure to protect. Trying to switch. Now, today our roundtable is focused on the paradoxical approaches to whistleblower protection, both from the European and American perspective. So this presentation aims to focus on one of the most important paradoxes that we have at the moment, the punishment of whistleblowers, from a particular perspective, that is the European perspective. Now, as you know, and this is generally how we say in any occasion, whistleblowers have played this crucial role in uncovering financial scandals, crimes, instances of unethical misconduct that impact also public interest. But, and this is the paradox, and this is probably the topic that we are analyzing today, many whistleblowers have often risked retaliation, faced investigation, prosecution, and conviction. When we talk about this topic, and this is from an European perspective, my question for today, for everyone, is are whistleblowers effectively protected from punishment in Europe? Because we know that Europe is a multi-level system where we have courts at the national level, at supranational level, and also the influence of international organization. And the assessment, at least for this presentation, that is 15 minutes, will be based prevalently on the legal instruments and the cases that we have in the European context. To delimit again my presentation, my attention will be focused on the relationship between the punishment of whistleblowers and the fundamental rights. That is something extremely important. And this perspective is crucial to discuss manifold points. I have listed them there, some of them. In particular, the tension between the imperative to punish individuals who disclose information in breach of the law and the conflicting need to protect these whistleblowers. Now, this is another paradox. The second point, when we study criminal law, I think in any country in the world, the first thing is the objective of the punishment. And generally, the objective of the punishment is deterrence. At least the traditional theories. Now we know that there are many others. But the point here is that analyzing the relationship between punishment and freedom means to analyze, in reality, the use of a punishment to discourage, in reality, the disclosure of wrongdoing. And then the relationship between punishment and human rights allows us also to discuss the relationship, the role of the criminal law and protections of certain goods, in particular, the balance between a private interest, often those of the corporations, and on the other side, the interest of the whistleblower and also the public, because this is, in reality, the scenario is much complicated than we imagine. And another point that was emphasized in the previous session chaired by David Benezer, and I think this point was raised by Costa and Professor Fiorelli, is about the protection of the rule of law. When we talk of freedom in the relationship with punishment, we talk of democracy and then rule of law. So this is the reason why I decided to select these, also for reason of time. At the same time, I asked to myself, Now I need to talk about punishment in Europe. From what perspective? Now in Europe, we have many states. And so the first perspective is to analyze different countries, but this is impossible in this time. At the same time, we have also supranational institutions. From this perspective, Dr. Grass already focused on the European Union and the recent directive. So at the moment, one of the most important instruments used in Europe to protect the whistleblower is the European Convention on Human Rights. And for this reason, I decided to focus on that. But at the same time, Europe means also international law, because clearly we are subject to the international framework, treaties, and declarations. So the point is that by looking to the Council of Europe and the European Convention on Human Rights, first, we are able to assess the common understanding among states about this topic. And second, to analyze how states operate in practice, and in particular, what are at the moment the problems. Now, generally speaking, this is more theoretical, but soon we will go to a practical point. When we talk of protection of whistleblowers in Europe, we need also to analyze the instruments. Generally, just to be simple, we can distinguish between a direct and indirect protection of whistleblowers. The direct protection refers to the case where you have a specific legal frameworks that protect the whistleblowers, leakers, and other subjects that disclose misconduct or other forms of conduct in the public interest. Different is the case of the indirect protection. Why? Indirect protection means that, generally speaking, you have a broader legal instrument, exactly the one that we are analyzing, the European Convention on Human Rights, that protects a right, a general right. But thanks to this general right, we are able to identify a specific right to protect whistleblowers. Now, by combining these, then we have a more big picture. At the moment, I can focus just on one. At the moment, you need to know that the freedom of expression is recognized in particular by these two provisions of the European Convention on Human Rights and the Charter of Fundamental Rights of the European Union. But what is important to remember is that the most relevant jurisprudence that we have at the moment to protect the whistleblowers has been developed by the European Court of Human Rights at supranational level. And the supranational level for us, the level is for us something extremely important. This is a topic that Dr. Grasso always repeats on many occasions, is an idea that we have, because generally supranational institutions are able to limit the states. And generally, whistleblowers suffer punishment due to the investigation, prosecution, and conviction of the state. But when we go to read the jurisprudence of the European Court of Human Rights, we start to discover that there are also technical issues to protect the whistleblowers through indirect protection, through general rights as the freedom of expression. The first is the concept of whistleblower. The European Court of Human Rights, to recognize the protection of a whistleblower from retaliation or also punishment, the first thing that generally does is to identify if the person, the individual, may be defined as a whistleblower. But in one of the recent decisions, I think David Bannister just published on Corporate Crime Observatory, one of the last decisions, the European Court of Human Rights clarified that this concept lacks a clear definition, a clear at international and European levels. Sometimes it is important, at least for the court, to assess case by case. What the European Court of Human Rights at the moment has established that the protection of whistleblowers is granted in cases where there is a private sector relationship between employee and employers, the same public sector relationship between employee-employers, or civil servants. This opens a big discussion about the protection of individuals that are not qualified as an employee. And so maybe professionals or other subjects. Another point is that the European Court of Human Rights, to assess the protection of whistleblowers, in reality has developed 6 criteria. And these criteria were refined recently with an important case in the Lux case that we will see. In particular, the court requires first to evaluate if the disclosure was made internally or externally, and also if first was made a disclosure internally. Second, the European Court assesses for the protection the authenticity of the information. And this is another important point, in particular, assess whether the whistleblower acted responsibly in seeking to verify the information to the best of their ability. Then the European Court of Human Rights focuses on the concept of good faith. This is another important aspect, very complicated, because there is a need to determine the motives behind the disclosure. And what happens if a person is not in good faith? Second, fourth, we need public interest in the disclosed information. This is a broad concept. The European Court of Human Rights clearly refers to crime. So when we are in presence of a crime, clearly there is a public interest. But when there are unethical misconduct, the situation is a little bit different. The main problem is the detrimental caused by the disclosure and the balance between the different interests at stake. Last but not least, the severity of the sanction. To protect a whistleblower, the court says it's important to assess the severity. So my question for you is, if a whistleblower is punished just for 1,000 euro, is it possible to protect the whistleblower or not, based on these criteria? We have, in reality, many cases. We have no time to discuss that. But one of the most important is the LuxLeaks case. I had the opportunity to study this case for some years in our group of research. And this case is important because it is an example of corporate state failure to protect whistleblowers in Europe. In practice, what happened? In Europe, multinational companies, together with Luxembourg, the government, did tax rulings. What are tax rulings? Advanced tax rulings are perfectly legal agreements about the tax to pay, but in reality, they reduce the amount of tax to be paid by citizens. Now, by multinational companies. What is the problem at stake? This means that in Luxembourg, there were many multinational companies that paid their taxes to the government, and in reality, they paid just a little amount, a very little amount, while common citizens are required to pay generally a huge amount of taxes. In this case, we had these tax rulings. Initially, hundreds of documents were disclosed by one of the former employee of this big accountancy firm who supported the signature of this tax agreement. And unfortunately, the first whistleblower was investigated after the report of this accounting firm, and he was convicted. But after initially was convicted, thanks to the jurisprudence of the European Court of Human Rights that was used by the Supreme Court in Luxembourg, he was finally acquitted. But together with this first employee who disclosed a lot of documents, hundreds of documents, there was another employee that at the same time and after the first disclosed just a few documents, just 16 documents. After there was already a TV show on this matter. So what happened? That he was investigated because he disclosed information related to documents that were confidential. But in this case, the courts in Luxembourg decided that it was responsible for having disclosed the information. In particular, they say that in this specific case, the person was in good faith at the moment when he took these documents. But then the court said, now the case was raised already. There were already discussion about this specific topic. So there was no need just to disclose 16 documents and then not do another TV show on this. For this reason, the whistleblower was convicted. But what happened? And this is what happened in Europe, where we have a multi-level system of protection of human rights, and where also our state should take care of international sources. The LuxLeaks case demonstrates the importance of these mechanisms in addressing the paradox of the punishment of whistleblowers. The employee who was convicted in Luxembourg applied to the European Court of Human Rights, alleging the violation of the freedom of expression. Here we had another decision of the European Court of Human Rights, the third section, that unfortunately argued that there was no violation of Article 10 of the European Convention on Human Rights. But at a certain point in February 2023, and this is the decision commented by David, the Grand Chamber emphasized the importance of considering the context of the disclosure, the ongoing public debate on tax practices, and in particular, the court said that information disclosed were of a significant public interest. And for this reason, this information and the value of this information justified the detrimental effects. For this reason, the Grand Chamber convicted a state. So when you look all this, and I would like to conclude with these aspects, we can see that in the context of the European Union, there are important mechanisms to protect whistleblowers. But today, despite the efforts made both at EU level, European Union level, and also within the Council of Europe, unfortunately, we have still many cases. The last one is Football Leaks with another conviction, where whistleblowers or leakers, but here there is also a discussion about the distinction between these subjects, are convicted. The problem to use of freedom of expression to protect whistleblowers is first, freedom of expression recognizes just the negative obligations to not be punished. But the freedom of expressions can recognize, at least through the interpretation of the court, positive obligation to do, and so to protect through rewards whistleblowers or imposing duties on corporation. Second, third point is the legal ambiguity and uncertainty that we have at the moment within the jurisprudence of the European Court of Human Rights. It's a case-by-case approach, but it is very difficult in certain cases to understand a priori if it's possible or not to act as a whistleblower. And this uncertainty has an effect not just on the whistleblower, but also on the companies. And last but not least, the balance between the rights of whistleblowers with the obligation imposed by the legal systems can be challenging. We have no time, but we have, if you have the opportunity then to read the volume that Dr. Grasso is publishing in this moment, you will discover that this balance is one of the most critical aspects. Paradoxically, when we read the LuxLeaks case, we had many judgments on the same case with the judges deciding in completely different way. This shows that sometimes it's not just a matter of law, but it's a matter of values that guide our judges. Thank you very much for your attention.